Hello everyone, my name is Sharmin Chougule and I'm a PhD student under Lucia Ruggeri in Jurisprudenza. And in this video, I'll be case commenting on one of the climate change litigation cases. So let's start. This case is about Indian Council for Enviro-Legal Action versus the Respondent, Union of India and others, etc. In this video, I will be dividing the analysis into 4 sections. That is, first is introduction, second is analysis, which is the case analysis. The third is the implication of the decision of the court, and the fourth is the conclusion. So to start with, into introduction, the case is basically a landmark case that holds immense significance in the field of environmental law in India. This case revolves around a crucial legal dispute concerning environmental protection and conservation. The Indian Council for Enviro-Legal Action, a non-governmental organization dedicated to environmental causes, filed a case against the Government of India, the Government of Rajasthan, which is a state in India, Rajasthan Pollution Control Board, which is RPCB, which is Pollution Control Board. For each state, they have their own board, Pollution Control Board, and a group of chemical factories, alleging them to be responsible for abiding by the environmental policy and regulation in India. The case raised vital questions regarding the balance between economic development and environmental preservation. So that was the introduction part. Now, for the analysis part, I have divided the analysis into significance, background, the facts of the case, the issues involved, dispute at hand, arguments, and the responses of the parties. So let's understand the background and key facts. So what happened exactly was there is a small village called Bichri in Rajasthan, in the Udaipur district of Rajasthan, India, and as in many other states also, like we have industrial settlements in every states, right? In this one, we had it near this village, Bichri, and it was a major industrial settlement of a public sector concern in this part, and it did not affect the Bichri village until a certain time. So when this case was filed, it was filed against the respondents along with the Government of India and Government of Rajasthan. Why? Because it's considered as a duty of the state to along with the Pollution Control Board to also look in the pollution related problems. So in 1987, Hindustan Agrochemicals Limited, which is the fourth respondent in this case, started manufacturing chemicals like oleum and split superphosphate. And it's another sister concern, Silver Chemicals, which is respondent number 5 in this case, began manufacturing H acid, which was primarily for export purposes. Rajasthan Multi Fertilizers, respondent number 6, Phosphates India, respondent number 7, Jyoti Chemicals, respondent number 8, were also operating, these are all respondents, without no objection certificate. A no objection certificate is basically procured from the Pollution Control Board to go ahead with certain manufacturing of certain chemicals which are classified as certain chemicals which are toxic until the time you do not have clearances as to which chemical you are manufacturing. You cannot go ahead with the production or manufacturing of it. So basically they did not have the no objection certificate, and we will see later what are the facts really as to how they proceeded and in what manner they proceeded and which chemical they were producing without the no objection certificate. So this manufacturing process was the manufacturing process included highly toxic effluents, including iron-based and gypsum-based sludge, which posed a serious threat to the environment if not properly handled and disposed. So in this Bichri village, this H acid had poisoned everything, earth, water, and everything that came in contact with it. The water in the wells and streams turned dark and dirty, rendering it unfit for human consumption. It became unfit for the cattle to drink and for irrigating land. The soil became polluted, rendering it unfit also for cultivation, which was the main economic activity of the villagers. It spread disease. There were deaths in the village and the surrounding areas. So these effluents from the plants were polluted in the nearby drain, and it overflowed into a canal which is called Udaysagar Canal, severely corroding its cement concrete. Even the cement concrete was corroded, so that is the kind of toxic effluent which was dumped in there. About 60 wells were significantly polluted. The manufacturing process resulted in the production of 2,500 tons of toxic sludge and 375 tons of H acid. The sludge was dumped into the open fields of the village. What further happened was that these contaminants with the rain leached into the soil and polluted the aquifers and subterranean water supply, rendering the water unsuitable for drinking, irrigation and other purposes. Now, it comes the law and order in the picture. The district magistrate, which is the lower court of the class, implemented section 144 of the Criminal Procedure Code, that is CRPC. What this CRPC talks about, section 144, is that it's the power to issue order in urgent cases of nuisance of apprehended danger. So this order under section 144 led to the closure of silver chemicals in January 1989. We will also look at the timeline one by one while proceeding with the analysis of this case. So in August 1989, the Indian Council for Environmental Legal Action, which is the current petitioner in this case, filed a writ petition seeking effective remedy measures to address the situation. The Rajasthan Pollution Control Board stated that the units had violated regulations by manufacturing certain chemicals without approval. The Supreme Court ordered the National Environmental Engineering Research Institute, which is called as NERI, to conduct a study and recommend short-term and long-term steps to mitigate the pollution. Because the court has the power to appoint an amicus curiae to help in the investigation of the case. The court ordered the Ministry of Environment and Forests, Government of India, the respondent in the case, for the removal of sludge lying on the ground to prevent further contamination, and instructed to send specialists to inspect the area and recommend treatment and disposable procedures with the provisions. The provisions here are referred to the provisions in the Act Hazardous Waste Management and Handling Rules 1989, framed under the Environment Protection Act 1986. So we can understand that this was the era for India where a lot of environmental protection legislations were also being enforced or brought in place. Further, the facts are that the court held that the factories entirely are liable for compensating the affected villagers and taking appropriate steps to eliminate the contaminants. Despite the court's final judgment in 1996, the case remained unsolved due to interlocutory appeals and non-compliance. This is one kind of loophole in every legal system, where parties try to delay a certain order made by the court to pay a certain amount. Like in this case, the respondent was supposed to pay the villagers, and for the damages to bring back the affected area to a certain level of recovery. And they tried to put a lot of interlocutory appeals and certain requests in between, which delayed their compliance with the court's order to pay that certain amount, which the court had asked them to pay for 15 years. So we are going to see the details of that later in this video. So MC Mehta is one of the very well-known advocates in India who generally files cases related to environment and any problems or damages made to the environment, and he was the advocate for on behalf of the Indian Council, which is the petitioner in the case. He emphasized the need for compliance, payment of damages and restitution to those affected by the pollution in this case, by filing another writ petition 15 years later. What we do understand from this is that Article 32 and 21 of the Indian Constitution were invoked to grant damages and hold responsible the parties for criminal liability for exemplary damages as a deterrent. Now, let's look at the issues. So there were main three issues, or primarily three issues, which further raised three further questions, but I'm not going to get into the technicality of the rest three questions, but primarily the main three issues, which are: what is the measurement of a commitment of an enterprise that are effectively associated with a particularly perilous or innately risky industry, if by reason of a mishap or occurrence in such industry, people are hurt, the people nearby. Now, there is a rule in law that we always refer to as a common law country, Rylance versus Fletcher. In this issue, which was raised in this case, was whether the Rylance versus Fletcher rule will apply in this case. And the third is that if the respondents will pay the sum needed for the health reasons of the villagers and the places nearby, will that sum be the sum which was ordered under 1996 judgment, or will it be with interest compounded for 14 years of deterral because there was no payout for the aggregate? So the next part which I would like to cover in this case comment is the analysis of the constitutional provisions which were brought into question. So the Indian Constitution, under its Article 48A, talks about the need of the state to protect and improve the environment and to safeguard the forests and wildlife of the country. While the second one is Article 51AG, which is a fundamental duty on each of the individual to preserve and develop the natural environment, including forests, lakes, rivers, and wildlife, and to value living creatures. Now, one thing that we need to note here is that the fundamental duties are not enforceable in the court of law, but are just duties on the citizens in general legal parlance. Then Article 21 and 32 of the Indian Constitution were also brought into question. Article 21, which talks about protection of life and personal liberty, where no person shall be deprived of his life or personal liberty except according to the procedure established by law. The second is Article 32, where it talks about providing exclusive right to an Indian citizen to file a petition whose fundamental right is infringed by some means or other. So in this case, because the protection of life and personal liberty under Article 21 was infringed, a person can go to the court, the Supreme Court, which is the apex court of India, for filing a case, a petition under Article 32. That's what our current petitioner did in this case. The arguments, there were some arguments raised, presented by Indian Council for Enviro-Legal action, particularly includes all that we covered in the first part where we spoke about the background and facts. Interestingly, the arguments presented by the respondents, on the other hand, what did they have to say? So Hindustan Agrochemicals Limited particularly pointed out that there was a no objection certificate given to them, while the certificate which was given to them was for the production of something else, that is sulfuric acid and alumina sulfate, and not oleum and single superphosphate, but they were rather producing oleum and single superphosphate. On the other hand, the arguments presented by the Ministry of Environment and Forest, Government of India, was that the Silver Chemicals, one of the respondents in the case, was merely granted a letter of intent and not an industrial license, while the Ministry of Environment and Forest and RPCB, which is the Rajasthan Pollution Control Board, were fighting with each other and blaming for the lack of progress in the removal of sludge from that area. So the legal basis and grounds for their claims were particularly Environment Protection Act, which we saw before, the Water Pollution Prevention and Control Act, Air Pollution Prevention and Control Act, Forest Conservation Act, Article 21 and 32 of the Indian Constitution, because that is enforceable in the court. And overall, the arguments were grounded in environmental laws, regulation, constitutional provisions that aim to safeguard the environment, protect communities, and promote sustainable development. what were the implications now of this decision? Because this decision came out to be a landmark judgment, so we need to, as a lawyer, significantly identify and critique the decision of the court. So in this, I would say after 15 years, when the judgment came out again for the writ petition which was filed by MC Mehta, about 15 years later, in this definitive judgment, the court applied polluter pays principle, and it made these respondents liable for 15 years of accumulated interest at the rate of 12% per annum from April 11, 1997 for 15 years until the date of the judgment, and tried to make good the damage which was made by them for reviving the area, which was environmentally so polluted that there was so much annihilation. So the important takeaways are that the court applied polluter pays principle, which makes the person who has committed this kind of criminal activity, where has polluted the environment to a certain level, has to also pay up for the tidying costs. So in the end, I would like to point out what are the impact and significance of this judgment. It has strengthened environmental protection in terms of giving some power to the citizens to take this as a common law country, a decision of the court, stare decisis, which can be used in another case as such, as a deterrent for the respondents and the potentially future respondents to not commit such a crime. Promote sustainable development, empower civil society and NGOs like the current petitioner, Indian Council, and raising awareness and consciousness for everyone, like the public awareness about environmental issues and the importance of environmental governance. In concluding part, which is the fourth part, I would like to again point out that sustainable development, given the fact that it's a basic necessity for human survival and our future as humans, this decision was very much necessary. The court, for the first time again, implemented the polluter pay principle, as the cost was compensated from all the big industrial businessmen for causing environmental damage and also risking the life of the villagers without treating the hazardous slurries of their plants properly. Sustainable development cannot, in terms of environment, we cannot say that because we are for or advocates of sustainable development, the environment can be really actually compensated for the damage that we have done, but to revive back the environment or the land that is being damaged, it is necessary to take such decisions by the court, especially our apex court, in order for the victims to be properly paid, appropriately paid, and for the polluters to not to rather be inhibited from doing or deterred from doing such a thing in future. As a case timeline, in the end, let me just point out that in 1989, the Section 44 was enforced to put an order in order to close all those respondent factories. In 1990 and 1994, the court further decreed that Indian Ministry of Environment and Forest should immediately engage their people to find out and inspect what is happening. 1996, Supreme Court passed a final order on 13 February 1996. Later, in 2011, because of the deterror by the respondents, 15 years later, the polluters, using the legal tactics, delayed the enforcement of the court's 1996 judgment, and on July 18, 2011, a writ petition was filed in Supreme Court by the same name, Indian Council for Enviro-Legal Action versus Union of India, and a final judgment came with the price to be paid by the respondents with a 15 years computed interest for the revival of the area. So that's all what happened, but we do need to understand that there are always two sides, which is the economic development and the environmental protection and preservation, and it needs to be balanced. And these big industries and multinational companies should understand their responsibility as a corporate house or a public sector undertaking or a private sector undertaking to also think about the society where they are living and the resources that they are procuring from the society. That's it. Thank you.